the case?
No, Your Honor.
All right, you may call the next case, please.
Vidafuel Inc. versus Kerry Inc.
Good morning, Your Honors.
Good morning.
Cindy Sater on behalf of the appellant, Vidafuel Inc. I'm here with my law partner, Abe Kuchai, and our co-counsel, Kevin Baltz. The CEO of Vidafuel is also here, Betty Parolini. I'd like to reserve 4 minutes, please.
4 minutes, all right.
In the short time I have before you today, I'd like to address the 3 main points raised in this appeal: the application of the economic loss rule, Vidafuel's standing under the TCPA, and whether Vidafuel has sufficiently pled when it discovered the wrongful conduct that forms the basis of its TCPA claim. Respectfully, the trial court erred on all 3 points, in large part because it decided incorrectly that Vidafuel's only complaint here is for defective products. It is not. Starting with the economic loss rule, in Milan, the Tennessee Supreme Court expressly declined to adopt a broad rule that would bar all fraud claims. Yet that's exactly what the trial court did here. Following the reasoning of Kaladi Enterprises versus Kellogg, the Wisconsin Supreme Court opinion in 2005, the Tennessee Supreme Court in Milan adopted the narrow fraud exception. It also recently confirmed that in commercial painting. The exception is this: the economic loss doctrine applies to bar a fraudulent inducement claim seeking recovery of economic losses if, an important word again, the only misrepresentations by the dishonest party concern the quality or character of the goods sold. Vidafuel's claims of fraudulent inducement and misrepresentation do not concern the quality or character of the goods sold. As set forth in paragraphs 43 and 45 of our amended complaint, Kerry misrepresented its expertise and ability to develop a formula that it could then manufacture in its Savannah facility. But for those misrepresentations, Vidafuel would have gone looking somewhere else for a manufacturer, and there would have been no agreement with Kerry and no non-conforming products.
If I am correct in my timing, the trial court had the benefit of the Milan supply chain opinion, but it did not have the benefit of the commercial painting opinion.
It actually did. Commercial painting came out while the briefing was in process. So by the time of the hearing, Your Honor, yes, it did have the benefit of commercial painting.
The trial court did?
The trial court did.
Okay.
Admittedly, the Tennessee Supreme Court has not applied the narrow fraud exception to a case such as this, in which there were in fact goods sold. It wasn't solely services agreement, but the representations were not limited to the quality and character of the goods sold. The cases cited by Kerry, East River, Lincoln General, Trinity Industries, Toasted Oat, those cases aren't on point because they don't involve a fraudulent inducement claim. The other cases that the court's familiar with, City of Franklin, Ritter, Huron Tool, they don't get us there as well because, like Milan, the representations in those cases pertained solely to the quality and character of the goods sold. But the Kaladi Enterprises, Inc. versus Kellogg, that case is on point. And that case was relied on by the Milan Supreme Court, relied on and cited to by the Milan Supreme Court. Kaladi was a reseller for certain Kellogg products, and prior to the purchase at issue, Kellogg changed its marketing scheme such that it was going to be impossible for Kaladi to then resell the products. The Kellogg reps knew this, but Kaladi did not. So the court held that the economic loss rule did not bar the fraudulent inducement claim because the representations or omissions in that case pertained to the marketing scheme. They didn't pertain to the quality or character of the goods sold. Thus, the fraudulent inducement claim was not barred by the economic loss rule, which is what should happen here. We ask this court to reverse the trial court's dismissal of Vidafuel's fraudulent inducement and deceit claims. Now, moving on to the statute of limitations.
Well, let me ask you this. It sounds like in your argument, in your pleading, you're trying to avoid the fact that there's a contract in this case.
We're not avoiding the fact that there's a contract, Your Honor. We haven't sued on the contract because we're suing for fraudulent inducement that misled us into entering that
Well,
contract.
you say you haven't sued under the contract, but in paragraph 45 of the amended complaint, you have language that says, had Kerry adequately and timely performed. Performed what? It's performance under the contract, isn't it? And you discuss this manufacturing sales agreement. What is that? Isn't that the contract?
That is the contract. That was the contract that Vidafuel was fraudulently induced into entering. But for these promises that we can reconfigure your formula, we can make you a whole new formula that our facility can produce to you, those were the misrepresentations that misled us into entering the contract.
Well, isn't it the real issue whether the conflict between the parties involves the subject matter of the contract, and the subject matter of the contract are the goods?
The subject matter of the contract would have been had they been able to produce the goods, correct. But what we're complaining about were the false promises that they made us, leading us into the contract that aren't the subject matter of the contract.
Well,
the subject matter doesn't.
Go ahead, I'm sorry.
No, I'm sorry. I didn't want to interrupt you.
No.
The subject matter of the contract isn't we can produce you this formula and here's why, or here's why our manufacturing facility in Savannah can produce this formula. The subject matter of the contract are the goods. But before we get to the goods, we relied on their promises that they can make us a formula that their facility could manufacture. This was going to be a whole new formula. They were going to have to redo the formula for these products in order for their facility to manufacture them. So, but for those promises, we wouldn't have gone with Kerry in the first place, and there would have been no contract.
Isn't that all subject to negotiation on the contract as to whether or not that what you're contracting for is actually done, or whether there's a warranty on the product, and all of those things are to be covered under the contract?
The warranties were covered under the contract, but whether or not they could produce us a formula that they could manufacture, that was not negotiated under the contract.
It could have been negotiated, couldn't it?
It could have been, but we weren't aware we were being lied to. So I mean, that's the beauty. That's what makes a fraudulent inducement claim unique. And that is why Tennessee jurisprudence accepts out fraudulent inducement claims when it doesn't form the basis of the contract. Because the negotiating parties we weren't aware we were being defrauded on their ability of their R&D team to make us a formula that they could produce. That was presumed and understood, and we relied on those promises that they were going to be able to do that when we negotiated the contract. So those promises are not a part of the contract, and those promises are what we're complaining about here, not the contract.
Where do we find that, what you're relying on, what the representations are?
In our complaint, Your Honor. At this stage, the facts in our complaint are taken as true, and all reasonable inferences are in our favor.
So you're saying the contract has nothing to do with the formula?
The contract does not speak about the formula, correct, Your Honor.
They're to produce goods, but it doesn't say what goods, or what type goods, or?
It does say what goods, it has specifications for the goods, and that the goods were to comply with the specifications, but it doesn't speak to their ability to rewrite our formula in such a manner that their facility could produce it. When we came to Kerry, we had a formula that was being produced, but it was in a different type of facility. So the formula had to be reworked so it could be produced in the Kerry facility, and that's where they failed us.
Does it involve the quality and character of the goods sold?
Their ability to manufacture.
It's all about the quality and character, isn't it? Isn't that what you're arguing about?
Once they're manufacturing it, it is. But prior to manufacturing it, they're developing us a formula. And those were the services that they provided in advance of the contract, that they agreed to provide in advance of the contract, that they misrepresented their ability to provide in advance of the contract. And so we never get to the contract.
Well, you said specifications. Explain that a little bit more for me.
The manufacturing services agreement has specifications that the products are supposed to comply to when they're manufactured.
For instance?
The ingredients, the viscosity, I'm not sure I'm understanding Your Honor's questions.
Well, isn't that going directly to the issue of the goods?
Those go to the quality and character. That does go to the specification of the goods. Yes, Your Honor.
Okay.
But But that's not what we're complaining about.
All right.
We're not complaining that the goods were non-conforming goods. We're complaining that the promises that led us into the contract were false. If you had been able to develop us a formula that you could manufacture, which is what you promised just you could before we sat down at the negotiating table to negotiate the terms and warranties in that contract. And those false promises are what are an exception to the economic loss rule because they don't pertain to the quality or character of the goods sold.
Well, the Supreme Court says that the economic loss doctrine applies if the only misrepresentations by the dishonest party concern the quality or character of the goods. What you're talking about is the quality and character of the goods. They didn't conform to what you said that they said they could perform.
Respectfully, for Your Honor, what we're complaining about is their ability to make a formula and to manufacture the goods at the facility. That would allow them to manufacture the goods at the facility. We're not complaining about the quality or character of the goods once manufactured. We're complaining about their ability to make us a formula that they could manufacture in the Savannah facility. That's what brought us to the negotiating table. That's what made us leave our existing manufacturer and come to Kerry in the first place.
And in your amended answer, you don't assert any contract claims at all.
That is correct, Your Honor.
You assert tort claims.
That is correct.
And that's
Fraudulent.
based on misrepresentation that led to the formation of the contract.
That is correct, Your Honor.
And you say that's an exception to the economic loss rule.
Correct. Because those promises that made us shift gears and go with Kerry and enter the contract, those promises were that we could make you a new formula that we can produce in our facility, which is a different type of facility than your previous or existing manufacturer is using. So it has to be a different kind of formula, but we can make that happen for you. And then the contract is we can manufacture these goods consistent with the specifications. But those promises before we get to the contract, those were the false promises that brought us to the negotiating table. And that's what fraudulent inducement is. And that's what Tennessee law protects parties like Vidafuel from.
Okay, you used your time.
Thank you, Your Honor.
Thank you.
How much?
Yeah, what about it, counsel? She says that the rule.
How about let's play Meadows?
I'm happy to get right into it too.
We'll let you introduce
Good
yourself.
morning. My name
Then you
is
can jump on.
Good morning. My name is David Turek. I'm admitted pro hoc vice in this matter on behalf of Kerry Inc. It's a pleasure to be in front of this court.
All right.
Your Honor, please.
Yeah, we know from almost every jurisdiction that if the misrepresentation, and that's what they're arguing, precedes the formation of the contract, that the economic loss doctrine doesn't apply to bar those tort claims. How is this case different?
I think that's an incomplete assessment of the standard. That's step one. Was it done beforehand? And then two, was it relating to the quality or character of the goods sold? But there's a second part of the analysis of what does that mean? And Milan goes on to say the quality or character of the goods sold is determined by what was actually, or was this something that could be actually dealt with in the contract? And was it dealt with in the contract? And it absolutely was here. The complaints in this case, the misrepresentation number one, is the manufacturing services were not adequate by Kerry. That's paragraph 34 of their complaint. Section 6.1 of the contract explicitly deals with manufacturing processes, and there's a warranty about those manufacturing processes. And you don't even have to get to the to the contract to figure that out, because in paragraph 14 of the amended complaint, Vidafuel specifically acknowledges that there's a warranty for manufacturing services and processes in the contract. So that is a matter that was dealt with specifically in the contract. The second alleged misrepresentation is about this formula. Well, the formula is part and parcel of the specifications, which are very detailed in this contract. We made a deal with Vidafuel We warranted that this product would meet these specifications. That's in section 6.2 of the contract. And again, you don't even need to get to the contract to make that finding, because in paragraph 14 of their amended complaint, they acknowledged there was a warranty that the products would conform to the specifications in the agreement. And these are very detailed specifications because you're dealing with a food product. So there's all sorts of regulations about caloric content, the elements and ingredients in the beverage. It's a very detailed list of 2 or 3 pages of specifications. So this is one of those cases where, yes, the misrepresentation allegedly occurred before the contract, but it goes specifically to the character and quality of the goods because it is something that can be dealt with in the contract. The Kaladi case is, sorry, Your Honor.
If you say the misrepresentation occurred before formation of the contract, and also the pleadings in the amended complaint setting out tort claims, how do we end this case on a motion to dismiss?
Because it was so apparent from the pleadings, those paragraphs I just cited to you, that the alleged misrepresentations were dealt with already in the contract. We made a deal with them about warranties for the exact alleged misrepresentations that they claim existed here. We negotiated remedies. We negotiated limitations. We engaged in a 20-page written contract that also included an integration clause. An integration clause that said our whole deal, all of our communications, all of our statements, everything about this deal is memorialized in this contract. And our courts have consistently said that that's what we're going to hold sophisticated commercial parties to. We're not going to allow them to do an end run around their heavily negotiated contract and make up misrepresentations to pursue tort claims to bypass the deal that they agreed to. That is an emphatic principle of law echoed in commercial painting last summer, echoed in Milan. It is the purpose of the economic loss doctrine. And I think Kaladi, from my home state of Wisconsin, is a perfect example of how this rule, the fraud and the inducement rule, operates. It is a case where there were misrepresentations about marketing practices for the products that were going to be developed under the contract. The court said those were extraneous to the contract. There's no reference to marketing or promotion of those products in this contract. That is something that is extraneous to the agreement. Milan said, and I think this is really helpful, that if the bad acts, even the intentional ones, are covered by a contract, they remain in the realm of contract law. That's at page 150 of that decision. So Kaladi said, when you are talking about things extraneous to the contract, that is the proper basis for a fraud and the inducement claim. That's not this case. All of the alleged misrepresentations were something that were dealt with or could have been dealt with in this contract. And it is improper to allow fraud and the inducement to sidestep that deal. It would throw commercial predictability in business relations out the door. You would feel like you've got a deal, you've confirmed that this is the extent of the deal, and then years later, you have someone assert tort claims to try to bypass that deal. That would eliminate predictability in our commercial contracts. The second issue that's really been dealt with in the briefs is this a product case or is this a services case? And the commercial painting case acknowledged, that service contracts are not subject to the economic loss doctrine. But this is not a services case. This is a case about the performance of these beverage products. Were they suitable? Did they offend customers by their viscosity, by their taste? It is about the performance of the contract. And Judge, you did a nice job in the City of Franklin decision talking about what is a product liability claim and how do we know it's a product claim. And I think it's, you quoted a Kentucky Supreme Court decision that I think is really helpful here. A manufacturer of this is the Kentucky Supreme Court's decision in Giddings that you discussed in City of Franklin. A manufacturer of a product is not in the business of supplying information, but rather the product itself and only incidentally information about the product. The product and any information about its character, nature, or performance are properly the subject of the party's contract. So in this case, they've done some creative pleading and trying to establish that this is a services contract. But we cited some really good cases in our response brief that talk about services being something that's always incidental to the creation of a product. There's always a design, a manufacturing element, but that doesn't make a product liability case a services case. If it did, it would neuter the economic loss doctrine, because someone could always say, this is about manufacturing services. This is about how the product was created, the work that went into it. And courts have said, no, 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 we need to look at the fact that this is still about the performance of the product. Your complaint is all about how the product performed. That is a classic product liability case, just like the city of Franklin and the performance of the pipes in that sewer project were a product liability case. Moving on then to the TCPA claim. And again, I appreciate the court may look at things initially and say, this was a motion to dismiss. How can we decide these questions so early? This is one of the most detailed amended complaints I've seen in a commercial case. It is many pages long, and there's painstaking chronology of what happened and what led to the problems with this product. And those painstaking allegations detail multiple problems, alleged problems, with this product that occurred more than a year before the suit was filed. So again, for timing purposes, what matters is what did Vidafuel know, or what should they have known 1 year before they filed suit on June 1st, 2023. So what did they know before June 1, 2022? And what they knew was that there were at least 4 separate problems, 4 separate failed deliveries of this beverage product in August of 21, December of 21, February of 22, and May of 22. They also alleged in their own complaint that they sustained damages as a result of disappointed expectations with their products. They claimed that they lost customers at paragraph 19. They claimed that they had to issue customer refunds and free replacements of the products in paragraph 15. So again, all before a year before they filed suit, they had multiple issues with the products, and they acknowledged sustaining damages as a result of those products.
But your client continued to work with them, right?
We tried to work with them, and at some point there was a position where we ended the contract in March of 22, still more than 1 year before suit was filed, because there's an allegation in this case that we essentially assured them, or misrepresented, or continued to assure them that we could provide these products, and they were duped into not filing suit right away. That is belied by that March 22 cancellation of the contract, where they acknowledge in their complaint that Kerry conceded defeat. And that should have been a red flag at that point to Vidafuel, when coupled with their losses, when coupled with the number of products that had failed, that they should have been investigating their claim. That at that point, their notice inquiry was triggered. And at that point, the 1 year should commence. And even if you say at that point, well, there were some allegations or some acknowledgments or some assurances made after March 22, on May 31st, 2022, still a year before the statute of limitations, or before suit was filed, there's an admission in the complaint that they received the worst batch ever of our product. That would have eliminated any kind of assurances that we provided, and at that point would have been the largest red flag in front of their eyes that they had a potential lawsuit to file. But yet they waited more than a year to file that suit. So this is one of those, and I'll admit, rare instances where the court can find statute of limitations that they knew or should have known they had a claim more than 1 year before they filed suit, based on the detailed allegations in the complaint. And it's not unprecedented. The Court of Appeals in the Schmenk, there's a couple cases that sound very similar, so I apologize. There's the decision that says, as a matter of law, I think it's Schmenk from the Tennessee Court of Appeals in May of 2008. It was decided on a motion to dismiss that there was an obligation to commence suit earlier. The Eldred's decision from the Tennessee Court of Appeals in 2017 also says this is an issue that can be decided as a matter of law. There's not a need for a trial in this case because their own pleadings establish all of the elements that you would need for the discovery rule to apply. Injury, knowledge, a concession of defeat by Kerry, all of these things were what the circuit court looked at and said, as a matter of law, we can decide that the statute of limitations is triggered here. And then the second basis for the TCPA claim being dismissed by the circuit court was essentially a straight following of the Milan decision and ruling that this is an issue or misrepresentations about goods. And when there's misrepresentations about goods, only individuals can bring that kind of claim under the TCPA. And because Vidafuel is a business, a corporation, it is not an individual, and it did not buy the products primarily for personal, family, or household purposes. Now, I think on rebuttal what you're going to hear is that the TCPA gives standing to corporations to file suit. But that is a generic recognition that corporations can file suit under the TCPA, but it does not address the specific claim that was brought here by Vidafuel, which is under 4718-104B 5 and 7. Those specific sections that deal with goods, which is what this case is about, not services, require that they be brought by an individual bringing a claim about misrepresentations for the household or family or personal purposes.
Let me ask you this, because this is a motion to dismiss, isn't the court required to look at the pleadings only in this case, other than, I understand the economic loss doctrine argument, but under the TCPA, these pleadings simply talk about the services part of it.
This court...
Are we supposed to extend that, look at the contract to determine that, or how do we get to goods in those pleadings?
Right. This court and the circuit court has no obligation to accept conclusory and legal allegations as true. Those are not factual allegations. It has the obligation to scrutinize those and really analyze what is this case about in the context of looking at the contract. So you do not need to blindly accept those allegations. The circuit court did not. You have the obligation to scrutinize those beyond the conclusory assertions in the complaint.
Look beyond the pleading.
Look in the pleading itself and in the contract that is a part that was that the complaint was founded upon. Yes.
To determine what's really being talked about.
Correct, Your Honor. Yep.
How did the trial court rule on your statute of limitations argument?
Granted, it said the statute of limitations applied. Again, acknowledging that this is a kind of a fact, and he called it factually intensive dispute, but looked at the complaint and said, all the facts that are relevant are actually acknowledged here by the plaintiff. They effectively pled themselves out of court by the level of detail that was in the complaint.
Okay.
Let me ask one question to follow up on what Judge Golden asked you. You said the court could look at the pleadings and the contract?
Correct, Your Honor.
Was the contract part of the pleadings?
It was not, and there was an issue in front of the circuit court.
Well, then how can the court look at the contract?
Under Rule 10.03, because the contract was, because the complaint was founded on the contract. In other words, you can't have a fraudulent inducement claim without a contract.
I understand what you're saying, but I'm trying to ascertain how the contract even came before the court. If the complaint was not based on the contract, I'm assuming the contract wasn't attached to the complaint.
The contract was attached to our motion to dismiss, and the circuit court did not rely on the contract to make its decision. We raised that issue here on appeal, that is something the circuit court should have done. But you can make a conclusion here, you can affirm the circuit court by looking solely at the pleadings because of the descriptions about what this transaction was really about.
Just wanted to clarify that. Thank you.
Thank you.
And the court is correct, the contract was not included in our, attached to our pleading. We're not suing for breach of contract. We're not suing on the contract. We're complaining we are fraudulently induced to enter the contract. So the contract's terms were not before the trial court, and the trial court agreed that it was only going to rely on the pleading.
So the contract did not rely, or the trial court did not rely upon the contract, so there was no need for you to object to the contract, I take it.
Correct.
Okay.
That is correct, Your Honor. In the city of Franklin, the complaints there were that the pipes were not strong enough and the pipes did not last long enough. The complaints were about the pipes. Those were the goods sold. In Milan, the complaints were about the trucks. Those were the goods sold. The complaints here are about their ability to provide a service that predated the contract. That service was developing us a new formula. Those samples that they sent that were great, those are misrepresentations about their ability to develop a formula that their facility could then manufacture. We never got a formula that the facility could manufacture. They never developed us a product. They never manufactured a product that was consistent with that formula they said they could do. So the fraud in the inducement is in the formula. That's not in the contract. We're not complaining about the quality of the goods manufactured. We're complaining about the formula that they were never able to develop and deliver on. And those were services that predated the contract. And those misrepresentations should not be subject to the economic loss rule because they don't concern the quality, the character, the nature, or performance of the goods. We never got that far. We're complaining about their ability to develop us a formula. And the TCPA claim is complaining about those deceptive practices, those deceptive representations that our R&D team can make you a new formula. That's what's deceptive, not the products themselves.
And are these claims timely, counsel?
Yes, because we did not learn about the falsity of those promises until that June 3rd, 2022 Teams call. And on that call is when we learned that the facility wasn't able to produce it. They were having manufacturing issues. They were having staffing issues. That was the moment when Vidafuel learned the falsity of the representations that we can make you a new formula, because that's when we learned they didn't and they couldn't. They couldn't deliver on those promises. The ability to develop a formula didn't have the characteristics and qualities that they assured us it would.
What about the point in time where I believe it says in the complaint that they conceded defeat?
They conceded defeat on their ability to deliver us products that met with the form. We knew we were getting non-conforming products, but we didn't know that was because the formula was failing. We didn't know it because the formula that they had promised us they could deliver on wasn't, their manufacturing services weren't able to develop it. So we knew we had non-conforming product. They never got us a product that met the formula samples that they had previously provided us. So we knew the products were failing more than a year before filing a suit, but we didn't know the reasons why. We didn't know that those misrepresentations from the beginning about the ability to find us, to develop us, their R&D team to develop us a formula. That's what our complaint is complaining about. Their R&D team to develop us a formula that their specific type of facility could manufacture. We didn't know that those misrepresentations were false until the June 3rd Teams call. That's what our complaint states. And those facts in our complaint, they're not conclusory allegations, but those facts in our complaint must be viewed as true at this stage in the case.
Thank you.
Thank you.
Thank you, counsel. We will take this matter under advisement, and we'll do our best to get you an opinion at the earliest possible time. You may be excused.